Good morning. We're here today for oral argument in the case of Bodega Latina Corporation, Safety National Casualty Company versus the ICA Adela Zubiate. Am I pronouncing that correctly?
Sounds good to me, Your Honor.
Okay. It's our case number CA-IC23-0001. We have conferenced this matter this morning. We're relatively familiar with the record and the briefs. Just keep that in mind during your argument. This matter will be live streamed on YouTube and recorded later so that when you get up and introduce yourself, or when you get up to make your arguments, please introduce yourself and tell us who you're representing so that the 3 or 4 people who will watch it someday will know who's who. Each have 20 minutes. It's up to you to reserve your time, appellant. If you want to save any time for rebuttal, it's up to you to do so. And is there something I forgot? No. With that, I will let you proceed.
Thank you very much. Thank you for inviting us here today. I represent the appellant, the defendant employer, and the defendant insurance carrier. And I believe the issue presented to the judge was whether or not Ms. Zubiate had suffered a new injury, or were we simply dealing with a progression of an underlying disorder that manifested itself as you would expect with lifting boxes at work that resulted in pain. Similar to a situation where I sprain my ankle at home, it's painful, I go to work, I walk on it, it hurts. So is that a new injury, or is that simply a manifestation of the symptoms you would expect from my non-industrial injury? And that kind of case requires an expert to analyze it, look at the prior records, take a history from the patient, and determine whether or not we're actually dealing with simply the progression of the pre-existing disorder, or are we actually dealing with a new injury? Which is why the defendants in this case hired Dr. Lyle Young, board-certified orthopedic surgeon, fellowship trained in spinal surgery, to meet with the injured worker, take a history from the injured worker, and review all of her prior records to find out whether or not this was actually a new injury or simply a progression of the pre-existing herniated disc that would result in pain with any type of significant lifting activity, which would not be a new injury because it wouldn't require any treatment that she didn't already require. We know from Dr. Young that she was probably a surgical candidate from this pre-existing herniated disc before this alleged injury, with this injury originally occurring in 2017, worsening in 2019. The injured worker was under treatment for that pre-existing condition, and she specifically testified at page 25 and 26 of the hearing transcript when asked by opposing counsel, tell us the difference between before the injury in January and after the injury in January, and she said there was no difference. And she was asked several times, and each time she said no difference. And that was similar to the history that Dr. Young got from the patient when he would ask her, when did your symptoms begin? 2017. Any difference now? No, not really. He reviewed the MRIs. He reviewed the records, and he concluded that we were not dealing with a new injury. What we were dealing with was the progression of her underlying disorder, which required surgery, but not as a result of any industrial episode occurring in January of 2021. Testimony was also taken from her treating physician, Dr. Jackson, and he saw her in April of 2021, within months of the alleged industrial injury. And the history he took from her, as he testified to at hearing, was, my pain began 3 years ago. He reviewed the MRIs that were available. He couldn't identify any acute pathology. He was asked, well, can you say whether or not she needs treatment now, or if her symptoms are related to this new incident or the pre-existing condition? And he admitted, I can't say. I have no opinion on that because
Counsel, let me
go ahead.
Interrupt briefly here. You're doing a great job of reciting the evidence that strong evidence that was presented during the hearing in your favor. But the ALJ heard that evidence and rejected it. So
And
I believe we're bound by a standard review that says we've got to defer to the ALJ's resolution of conflicting evidence. So can you tell me where legally there's something that we need to do to correct an error?
Sure.
So not just reweigh this evidence.
Gotcha. So when you read the case law, I think the case law stands for the proposition that where there is medical testimony from experts who have examined the applicant and taken a history from the applicant and reviewed the records, that the judge cannot select a medical record that has no history in it, that simply relies upon a statement from the injured worker that my back pain occurred at work, and use that to find that this is a compensable injury when the medical record has none of the pertinent medical history. In other words,
Counsel, is it true that there's absolutely no history inside of that medical record? I mean, I'm looking at it right now, and it says, injury history has been previously documented and symptoms are worsening, and contains a statement about anterolisthesis at L4, L5, which is unchanged. Now, that's equivocal on where it gets worse or it gets better, but that to me tells me that there's at least some consideration of medical history in this document.
And in fact, didn't this provider see this client previously?
no, this was, so
I thought we'd seen somewhere in the record that
That was
there's a
the-
reference to Dr. Island having seen this patient for previous, no?
no. So
Dr. Island didn't see her in May of 2020.
no,
So Dr. Young's report is wrong when it says that she saw Dr. Island in 2020.
no, she did not see, Dr. Island did not see the injured worker before the injury. So Dr. Island wasn't a family doctor. So Dr. Island is, so there's Concentra and then there's MBI. And if you're injured at work, the employers such as this one usually send you either to Concentra or MBI. So she was sent to MBI, and I think she saw Dr. Island for the first time on January 7th, if I'm not mistaken. But that was the first time she ever saw Dr. Island. And when you read Dr. Island's medical record, there's no history in there of any pre-existing herniated disc or symptoms pre-existing the industrial injury.
So in Dr. Young's report on page 5, at the very first paragraph, when it says January 2020 or January 23, 2020, Concentra Medical Center, Jacqueline Island, MD, that is incorrect.
If Dr. I don't know where that comes from. The only records that
It comes from Mr. Young's report.
But the only records that were entered into evidence was the record from Dr. Island after the industrial injury. It might very well be that Dr. Island, you may be correct and I may be wrong, that Dr. Island had seen the patient one time before for a 2019 injury or a 2017 injury, but that was not in any of the records that had been submitted into evidence. So when you read her record that the judge relied upon, the one record the judge relied upon, she specifically notes or fails to mention any pre-existing medical records that she reviewed or any history she had from the patient that pre-existed the visit on January 7th. So take a look at her record if you would, and there's no medical history in there. It has a history of the injury, but it doesn't have a history of any pre-existing herniated disc or condition.
I see injury history previously documented in that record that we're talking about.
January 7th. But there's nothing in there. And there's nothing in those records that shows that there was a pre-existing, it says previously documented, as do all those records, but there's nothing in there. It doesn't say that she actually had a pre-existing condition for which she was receiving treatment at the Core Institute. That's nowhere in that record. And so you've got two doctors who examined the patient, who reviewed the records, and concluded that it wasn't possible to say that this was a new injury. So you take a look at the cases where the injured worker prevailed with a simple medical record. And that's, for example, modern trailer sales prevailed. But there was no medical testimony offered to contradict that medical record.
Is in modern trailers, did that turn on whether or not there was medical testimony or not, or did it or did it turn on the presence of a causation opinion?
That was, one of the issues in that case was medical causation, and I believe that the appellant objected, saying that the record was insufficient for a decision for a compensable claim, and the Court of Appeals disagreed and said that when there was nothing to conflict with the medical document that was submitted into evidence, that was sufficient.
Well, was it the conflict, or was it just the fact that it was obvious that the injury was patent and any layman could see it?
It's not clear, I don't think. Because the court did say that the medical document did support the decision for a compensable claim. Same thing in El Dorado, same thing in Estes Corporation versus Industrial Commission. Every time we have one of these cases where there's a medical document that supports the decision for a compensable claim, there is no controverting medical testimony or any other controverting medical document to show that the doctor who authored the report is incorrect.
Well, let me take where you're the logical extension of where you're going. Let's change things up a little bit. Let's say that this record right here that we're looking at, it doesn't say what it says. Instead, it says, I opine within a medical degree of certainty that this injury was caused by that accident, but it's just the record.
Okay.
Now, you have Dr. Young's testimony that says, no, it ain't so. Same result?
No, and the reason being is that document that was submitted into evidence has no pre-existing medical history listed.
Well, we'll say that there is no pre-existing medical history. It's just a medical conclusion. This is my conclusion. Do conclusions by experts require supportive documentation to be introduced as well?
In a case like this, they do, where the issue is whether or not we're dealing with a pre-existing condition or a brand new injury. So if the treating doctor who saw the patient at MBI doesn't have a history in the document as to when the applicant was treating, what the prior MRI shows, then that doctor, any doctor presented with a situation where the patient comes in and says, I was at work today, my back pain increased, would say, this is a result of work. If they have the additional history, then it completely changes. Dr. Island would not have testified that this was a new injury if she had a complete history, in my opinion. She would have at least deferred to Dr. Young.
That's neither here nor there, because that would be complete speculation, would it not?
Having done this for a while and knowing the concentric doctors, if I had said, were you aware of this pre-existing history and the fact that a spinal surgeon has examined...
But it's not in our record.
Okay, understood.
Okay.
Understood.
So, but is it really necessary, at least at this point, for the conclusion, because what we're talking about, no history, just the opinion, okay, that this injury was caused by that accident, but no discussion of injury. You're saying, no, that's not good enough.
That would be insufficient because there's no history. Again, if Dr. Young had been presented with this patient and the only history he had was, I was at work today and I lifted a box and I had back pain.
Isn't that reweighing evidence?
No.
If the ALJ chooses to accept that opinion, which we've agreed is clear, okay, over testimony in court, isn't that reweighing evidence?
No, because the record is insufficient, just like in Campanell. It's insufficient because all you really have is this opinion. The patient told me they were hurt at work today, therefore they were hurt at work today.
Well, that's different because in Campanell, that was an injured person who brought a note from a doctor, and in the note it said, patient said this. And I'm not saying that. In my hypothetical, the doctor says, on my certificate, in my medical opinion, this injury caused by that accident.
No,
and that's still not sufficient.
Not in this case because there's no pre-existing.
Counsel, let me ask you a question.
Sure.
I'm sorry, if you didn't get your answer, I didn't mean to cut him off. Okay. What is Dr. Ireland's document?
I don't know. The judge didn't specify which document she was relying upon. She didn't give us a date. She didn't give us the record. She just says Dr. Island opined, which I don't think Dr. Island did, and there's a conflict in the...
Okay.
I don't think there was...
That's the point I was getting at. do you concede, or not, that there is a opinion in Dr. Ireland's document somewhere in this record?
No, there is no opinion. There's simply a statement that says the patient told me this. This is the diagnosis. We don't know if that diagnosis is to a reasonable degree of medical probability. We don't know if there were considerations for
So
other...
then why were you fighting, or not fighting, pushing back when Judge Fruya was asking if this document is what we're relying on, would it be enough?
No, and so not when you have controverting medical testimony from an expert who's reviewed the entire file. So I guess
What is the claimant's burden here? Does she have to provide an opinion, medical testimony?
she could provide a written opinion
Okay.
that specifies I reviewed the history and I've reached this conclusion, which is not what we have here.
Okay. So then if it was a document and it was written, which is I think what Judge Fruya was asking you, and it said, this is my opinion, we'd be in the situation of trying to reweigh that versus the live testimony of the witnesses that you presented.
Yes, yes.
But we don't have that, do we?
No.
Is your position anyway?
Yes, we don't have that because that record contains no medical history. That was what this entire case was about, was the pre-existing history. There is no history. There's just simply a statement, the patient told me X, therefore she was injured.
Yeah, but even if it said, patient told me X and patient told me she has this history, it still wouldn't be an opinion, would be your position, even if it contained a whole bunch of history, because the doctor didn't actually opine, just reflected the patient's recitation of events.
No, I would not go that far.
Because you're saying it can't be an opinion if you don't know the history. If she knew the history and documented that history and still concluded that this work event caused this injury, that may be an opinion.
Correct.
Because you'd have all the pieces of what a medical opinion looks like when a person has history, as this claimant did.
Correct.
So,
Wouldn't we presume that if the doctor said, I opine to a reasonable degree of medical certainty that this was the cause, what is there legally that you could point to say, we're not allowed to consider that if it doesn't also detail specifically what history she knew? Don't we presume that a doctor who's qualified would consider all of that in making their opinion?
No.
Why not?
Because that's not what doctors
What's
do.
your authority for that proposition?
Well, that's not how doctors work. They don't, if they had...
Right, doctors work by considering all of the evidence and then issuing an opinion. So if we see a document that says, I opine that X, we presume the doctors have considered everything they're supposed to consider.
No, I don't see it that way. I'm sorry. Because the doctor has to outline what they're relying upon if it's going to be sufficient.
Okay, you say has to. What is the authority that says that a doctor has to do that in order for us to consider it, or for the ALJ to consider it?
Well, there has to be a conflict in the medical
Okay, you
evidence.
say has to again, you need to cite something or quit saying has to.
All right. I don't have the citation right here in front of me.
Well, I'm not asking for this specific case, but is there a case that says that, or is there a statute that says that, or is there a BOMEX regulation that says that they have to?
There is case law that stands for the proposition that in order for where there is a conflict in the medical evidence, the judge has to make a decision as to which position is more likely.
Isn't that a foundational objection, really, that you should then object to the introduction of a record that doesn't have the foundation necessary to be an opinion?
It's just background information. You don't expect when you go to hearing that you're going to request cross-examination for every piece of record that's submitted, especially where the record doesn't have any of the pertinent history.
well, is that part of the problem here, is that you didn't see Dr. Island's note as some sort of opinion? And if you had, you might have been able to argue to the ALJ why it was incomplete, why it shouldn't be relied on, but because you just saw it as a note, your concentration was on the experts that were presented, and so it's kind of a surprise to see that she's relying on Dr. Island's note as an opinion.
Yes, especially when the judge has the right to call in witnesses themselves. So if that was going to be the case where that note was going to be the turning part of the case, why not invite the doctor to testify? Or why not note to the parties, I'm considering utilizing Dr. Island's opinion Would anyone like to cross-examine?
Did the claimant claim at the hearing that this was an opinion that could be relied on?
No.
Okay, so I'm just trying to get a sense of when you saw that that's what the ALJ was relying on, it was a surprise to you?
Yes.
And you're saying it may have been, and I can ask him if it was a surprise to him, that that was seen as an opinion that could be relied on for causation?
Yes,
Because
especially,
no one argued it.
yes, especially where it had no medical history.
Right, okay,
I'd like to reserve the 45 seconds I have, please.
thank you.
It's 44.
44.
We'll let you. I'm glad that you guys are able to laugh when I make my bad jokes.
You're just
so,
glad someone
yeah.
does.
Someone told me that when you took the bench, all of a sudden his jokes were all gone.
Good morning.
Good morning, Your Honors.
Morning.
My name is Adam Palmer. I am the attorney for Respondent Adela Zubiate. I'll mirror the court's pronunciation.
Mr. Palmer, were you surprised to see that the ALJ had relied on Dr. Island as a medical expert in this case?
Absolutely not.
Did you argue that she'd given a medical opinion when she wrote that note?
The medical record contains her medical opinions. It was admitted into evidence without any objection from the petitioners. It was considered by the court. The court by law is required to consider all the evidence as a whole, and then her sole purview is to decide which medical doctor is more probably correct, and she did that. For some reason, the petitioners throughout their moving papers continue to argue, for some reason, that two live sworn medical experts, somehow their opinions carry the day over a medical expert's medical records. That is not the law in this state. They didn't cite a single case that says that's the law, because it's not the law. I mean, they're relying upon the Campanelle case, which is a memorandum decision, not precedential. It's not persuasive. There's actual cases that are on point that discuss the issues before this court, namely the Modern Trailer and the El Dorado insurance cases.
Now, counsel, before we leave Campanelle, is not one way to read Dr. Island's report as a taking or recitation of history that Ms. Zubiate was saying to Dr. Island, in which case Campanelle would be very relevant.
That's how these are done. I mean, if a patient, an injured worker, presents themselves to a doctor, typically the doctor will say, what happened? How are you hurt? And in this case, the injured worker, Zubiate, told her, I was lifting and pushing heavy boxes. We learned through her testimony that the heavy boxes contained frozen breads and dough. And that's the history she gave. So that's the history that the doctor obtained. As a result of
the point of Campanelle is to say that when a doctor parrots back what a patient says, that is not an expression of a medical opinion.
That's not what happened in this case. The facts in Campanelle are totally different. In that case, the injured worker admitted that he presented no evidence at hearing that he provided causation relating his bilateral shoulder conditions to his industrial event. He asked his doctor, probably a buddy of his, to do him a favor, which has been punished because now it's in a published decision that talks about the doctor's letter is inadequate to establish medical causation. And he simply says he gave no opinion in Campanelle. He didn't examine him. That's not what we have in our case. He didn't do a physical examination. And he didn't take a history of what happened. He just wrote down in this letter what history was provided to him by his friend or by his patient.
Okay, since you brought up history and your counsel here, your opposing counsel here made much of the absence of history, let's go there. So in the documents of Dr. Island, where is the history?
So looking at Dr. Island's note of January 7th, 2021, it says, chief complaint, patient presents today with lower back injury. Date of injury, 3 January 2021.
And immediately after says self-reported.
Sure, but whenever you go to a doctor, you self-report. Her testimony at hearing was that she was sent there by her manager. But for some reason, the petitioners seized on was self-reported. That's what happens when you go to Concentra. You have to tell the doctor what happened while you're there.
Well,
So
let me
self-reports are
put a
red
fine
herring.
let me put a fine point on this. Sorry for interrupting, but let me put a fine point on it so that you can speak to the concern
Certainly.
that I have.
Certainly.
Which is, you have an ALJ who's relying on a particular piece of evidence, okay, to the exclusion of or to exalt above other evidence, arguably, which is, or not arguably, is more extensive. So you have reliance on one particular piece of evidence to accomplish a particular goal, which is to establish medical causation. Okay, so if you're relying on this particular evidence to establish medical causation, okay, so let's go back to the history part. We need to tease out what is the doctor repeating back, just parroting what the patient said, versus what the doctor is giving as her organic medical opinion. Campanelle tells us that those are two separate things, and one is sufficient and one is not. So a doctor, even though a doctor is giving the recitation, is parroting back what the patient said, Campanelle says that is not sufficient. So tell me where in this page, where in this record, it's not, we can clearly divine, it is not parroting back what Zubiate said. It is Dr. Island speaking as doctor, this is my opinion. Tell me.
Sure. I'll start out by saying Campanelle is not the law in this state on medical causation.
Well, I was on that panel, so it's convincing to me. So let's go from there.
Okay. So under the history, it says acute musculoskeletal injury history, injured on January 3rd, 2021. This is the result of lifting, and she was pushing a cart after lifting. Multiple occurred while at work. Injury history, right lower back pain. Pain does not radiate. Symptoms occur constantly. She describes her pain as sharp. She then does a physical examination of the lumbar spine and notes tenderness present in the lumbar spine and right paraspinal. Flexion, active range of motion of 20 degrees, painful. Extension, active range of motion of 10 degrees and painful. Lower extremities, 4 out of 5 testing with pain. She then does a x-ray of the spine and notes negative acute arterial listhesis L4-5 unchanged. Her diagnosis, based upon the history that she obtained from the injured worker, from the respondent, that she hurt her back pushing and lifting these boxes, frozen boxes of bread and dough. Based on that history, the Dr. Island then makes a diagnosis of a strain of the muscle, fascia, and tendon of the lower back and assigns a CTP medical code for that diagnosis.
So is it the diagnosis is the opinion is that what you're relying on?
I'm relying on all of it. The entire history of what happened, how did you hurt your back, gave her the history of the incident.
And I don't want to put words in Judge Faria's mouth, but what I would like, what I look for when I was going through the record is something where she says, I am opining that this happened, or this injury was caused by this event, as opposed to what they're arguing it was caused by. Is there anything what's the best portion of that document that you can point to that says that's what you can rely on, Judge Morse?
We don't need that. The decision in El Dorado Insurance specifically says that there's no language that the doctor needs to use.
I'm not saying magic language, but what's the point that I can look at and say, okay, this supports the ALJ's decision?
Again, all of it. The injured worker presented to the doctor's office, gave her a history of being injured at work, told her the mechanism of the injury, what happened, and then the doctor physically examined the patient, confirmed that she has complaints in her lumbar spine consistent with a lifting injury, makes a diagnosis of an acute musculoskeletal injury, recommends a course of treatment based upon the symptoms post-injury. Acute.
But is diagnosing
Sorry.
have to be related to causation? I mean, there's no question that this doctor diagnosed an injury that was before her, and the client self-reports that it happened when she moved something at work. Okay, so there's a diagnosis, but there's no medical history, there's no rule out, there's no, I mean, this, like we talked about earlier, I think if she'd presented as someone with no history, that may be more than adequate for causation. But we know from the evidence that there was history of injury in that area, in fact, from a work injury. So how do we take a diagnosis, which is clear, and separate it from a causation, which is what the ALJ needed evidence of.
She had the evidence contained. This record from Dr. Island is a better documentation of what was used in both the modern trailer and the El Dorado cases, where the Court of Appeals upheld the judges, the ALJ's reliance upon the medical records that were not objected to and were admitted into evidence. This document is better. It has more detail. It sets forth the history of this incident. It was a lifting and pushing incident. That's the history of the incident. Counsel made an argument that the issue before the court was whether it was a pre-existing condition or not. That wasn't the issue. The issue was compensability, whether the applicant sustained an injury by accident arising out of and related to work. That was the issue before the court. The defense from the petitioners was it was pre-existing. It didn't happen that day on January 3rd, and they denied the claim. And then the respondent appealed it. So the issue is compensability. The judge relied upon this detailed note that has a history of the incident. This Dr. Island did a physical examination, noted findings consistent with the subjective complaint of a back injury, and then recommended a course of treatment and took her off of work and made it modified because she couldn't do her job because of her injury sustained on this day, January 3rd, related to this pushing and lifting incident. The entire document. In the El Dorado case, the appellate court did a very detailed and elaborate explanation of the medical note itself. And in supporting the ALJ's decision that the reliance on that note was adequate, they found out that the notes showed that the physical examination occurred, just like in our case. There was a description of the accident from the injured worker, just like there was a history given in our case. There were symptoms after the incident that were noted and documented, and based on those three things, the doctor made a diagnosis. Again, you don't need magical causation language in that case. Based on those three factors, the appellate court upheld the ALJ's reliance on the medical note. In this case, the medical records from Dr. Island were not objected to. They were admitted into evidence, and the ALJ, as is her absolute right, relied on those and found Dr. Island's opinion set forth in her report sustained the burden of proof of the applicant both legally and medically and found the claim compensable.
Counsel, where we distinguished El Dorado and Spielman later in '88 because there were other potential causes of injury, how do you relate that El Dorado is more here versus Spielman more here? So because what the evidence does suggest here is that Zubiate had other potential causes of injury.
There's no history of that. Again, that's a defense from an IME doctor hired by the insurance company to give them an opinion that's favorable to their position. The fact is that the doctor wrote in her report twice, she used the word acute. That means it happened shortly before her examination. Not pre-existing, as the defendants have argued and the petitioners have argued in their moving papers. It was an acute low back injury. She didn't consider anything in the history. The records show the applicant testified that she was working regular duties without restriction at the time of this incident of January 3rd, 2021. So there doesn't need to be a history of a pre-existing condition. The doctor used the terms acute. In the petitioner's moving papers, several times they say that the word acute is not there. You all have read the record from Dr. Island. It's used at least twice.
But not in the assessment section.
It's not a SOAP note where it's well-defined the parts. But if you look at it as a whole, as the administrative law judge was required to do, it's all in there. There's a physical examination. There's a history of the incident, subjective complaints after the incident occurred. Based on that information, Dr. Island made a diagnosis, recommended a course of treatment, and there you have a compensable claim. It's an injury rising out of work.
Counsel, I want to, if we can, resolve what appears to be a pretty relevant conflict. Your colleague said you didn't argue this was an opinion. You said you did. Can you show me in the record or point to a place in the record where you said, Judge, we're asking you to rely upon the opinion given by Dr. Island?
The injured worker, the respondent, doesn't have to do that, Your Honor.
Well, you have to present opinion testimony.
It was presented as a medical record that wasn't objected to by the petitioners, and the court is
Judge,
required.
he asked you, did you argue? So just show me in the record where you said, I argued that this was an opinion that the court can rely on to meet our burden.
That argument wasn't made.
Okay, then what did you mean when you told Judge Bailey that you did argue that below?
I didn't make that representation, that it was argued below. I said that the judge relied on the medical record of Dr. Island that was filed into evidence.
If you remember when she was finishing up with your colleague, she asked, were you surprised by this? Did they argue this below? And he said no, and then you got up, and the first question she asked is, did you argue this below, or something along those lines? So do you want to clarify then? Because I'm feeling you're giving me a different answer than you gave her, and maybe it's just I didn't understand the distinction or the parsing that you're trying to do.
There's no specific testimony where the injured worker made an argument or her counsel made an argument addressing the court's question. The medical record from Dr. Island was admitted into evidence and was relied upon by the administrative law judge in reaching her decision that her injury was compensable.
Is there ever a point in the record where you said, Judge, by the way, take a look at this at Island's testimony because that's what we're relying on to meet our burden to present opinion testimony?
No.
Okay.
But it's the sole prerogative of the administrative law judge to resolve conflicts
Right.
in the medical testimony, as you pointed out. The ALJ, reviewing all of the evidence as required to do, can resolve the question of medical causation in light of any reasonable inference. That choice that she elects to make in determining which medical opinion is more probably correct cannot be overturned on appeal unless it's wholly unreasonable. Her opinion is wholly reasonable based upon the well-established law set forth in El Dorado and in the modern trailer cases. Again, the record from Dr. Island is far superior than that discussed in El Dorado case, and the Court of Appeals in both of those cases upheld the ALJ's determination that the injured worker suffered a compensable claim.
What do you make of counsel's distinguishing of El Dorado by saying that there was much more at play here, much more evidence than was presented to the El Dorado court, or in the El Dorado's record, that there was no contravening testimony, there weren't other records, there was only that record. So here we have lots of other testimony, and we have other medical records. What are we to do with that? Is it meaningless?
No, but the Ortega case specifically says that the court can resolve the conflicts in the medical testimony. That means that she could resolve the oral testimony under oath of two doctors in favor of a medical note that was given that contains adequate information to support her opinion. So it doesn't matter that there was live sworn testimony or it was just simply medical records that the judge was relying upon. That's not important. What's important is, does the medical record that the judge is relying upon support her factual finding, which can't be disturbed on appeal, and is her medical determination relying on the medical record and Judge Island's opinions within her purview? And it absolutely is. So it doesn't matter whether there was live testimony or just cold medical records. If the judge chose to rely on the cold medical records, this court can't disturb her decision unless it's wholly unreasonable.
But what I'm getting at here is where there is presentation of alternative causes, which is the point of Spielman, right? Spielman says this is not El Dorado because in El Dorado there wasn't other potential causes. Where there are no other potential causes, a layman can look at that and say this, in which case Ms. Zubiate's own testimony that that was the cause of her injury would have been sufficient, would it not?
It could have been sufficient if a lay person...
Provided there was nothing else.
Right, but in this case, there were multiple doctors, multiple opinions, 3, as a matter of fact. There could be 5, there could be 10, it doesn't matter. The court's allowed to decide which doctor she thinks is more probably correct than the others. And that decision cannot be overturned unless it's wholly unreasonable and based on the holdings in Modern Trailer and in El Dorado. This record from Dr. Island is far superior.
Is it not possible to read Dr. Island's report in the way that your opposing counsel has mentioned? That it's just a recitation of what Ms. Zubiate was telling Dr. Island? Is it not possible to read that record that way?
No, because that's how you obtain information. A patient comes to your office and you're the treating doctor and they say, my back's hurt. Well, how did you get hurt? And then they proceed to give them a history of the injury. Okay, I was pushing. I think it was Jackson, the treating doctor for the injured worker, testified in this case that the MRI that he observed in March of 2021 would be, the findings on it would be consistent with someone who had a lifting injury. So again, the history that you obtain from the doctor, that's part of your analysis. If she presents with a stubbed toe and she gives a history of lifting and pushing a box of heavy dough and bread, that would be inconsistent history, and the doctor wouldn't be able to make a causal connection. But we have a mechanism of injury consistent with the subject of complaint of low back pain, then buttressed by the physical examination by Dr. Island that supports the mechanism of injury. That whole document collectively is the medical opinion. Again, you don't
You're out of
imagine.
time, counsel. I'm sorry.
Thank you.
One point, just from a practical standpoint now, are the parties going to have to request a subpoena for cross-examination of every medical document that's submitted? Sometimes there's hundreds of pages of documents, 20, 30 different authors. Do we bring them all in to cross-examine them to make sure that the judge doesn't pick a record to support a decision?
Couldn't you instead just object to records on a limited basis? Say we don't object to this, but we object to anything in here that you could construe as an opinion?
Yes, but the rules require.
I don't know how much of a parade of horribles we need to be
Right, but
addressing.
the rules do require us to set forth the name, address of everybody we want to cross-examine. So from a practical standpoint, is that what we would have to do for every medical record that's submitted? Just on the off chance the judge might select it as opposed to the actual testifying witnesses. Thank you.
All right. Thank you both. We'll take this matter under advisement and issue a written decision in due course. We are at recess.